Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Good afternoon. Welcome back to the Court of Public Opinion. We have breaking news. I am the Recovery Addict. Thank you very much for joining me. I'm really tiny in the corner, though. We'll fix that here. We have some breaking news right now. Bringing it to you hot off the press. The ink has not yet even dried. We have, listen to my words carefully, we have another letter. We have another letter in the Sarah Boone case, but this one is from the judge. This one's from the judge. Oh my goodness. We have breaking news, just barely dropped. Thank you, Amber, by the way, and Calypson's Vixen, who was not only first in chat, but was the first to break this for us. There we go. We finally have it. We have everything we want. We have all the information about Sarah Boone. We have all the information, and I'm going to bring it to you now. We're going to read through the documents and tell you the news. All of this, well, we were watching OnlyFans. Okay, well, we were watching the OnlyFans spin in the courtroom up in Massachusetts, secretly. And I say secretly because it sort of flew under the radar. Secretly, the judge was meeting with Sarah Boone and her lawyer. And we have updates. We have a 16-page order, which has been posted as of today, now. Let's see if I can bring that up for you here. And let me first read you the synopsis. Okay, let's give you the notes, because in the docket, on the docket events, we have quite a bit. It says, per the court, this is dated today. Ready? Let's see. Let me put this up on screen too. Just one second, so you can see where we're looking. This is over in Orange County. There we go. Let's jump here. Make it big so an old man like me can see it. All right, so we're looking at Sarah Boone's case right here in Orange County Clerk of Court Records. Right here on the docket events. Check this part out right here. The dates for the trial remain the same, 10/7 with a hearing at 9/24. But there's a date for today that says, per the court comments, the court made findings that the defendant has forfeited her right to counsel. The motion to withdraw was granted. As a condition of Attorney Cashman's withdrawal, she shall provide the court an order for costs to obtain transcripts of depositions for the two witnesses she deposed. Upon completion of the transcription and the depositions shall be sent directly to the defendant at the Orange County Jail. Attorney Cashman shall file a notice with the court reflecting that the depositions transcripts were provided to the defendant. All previously set dates remain. All pretrial motions must be filed no later than the close of business on Monday, July 22nd. The court ordered Attorney Cashman to provide two boxes of discovery with the clerk marked as identification A and B. The court will reach out to the jail to inquire how to deliver to the defendant. They're facilitating the transfer of discovery to the defendant. Court minutes, also additional. The court addressed Attorney Cashman's motion to withdraw. The defendant was placed under oath. The court read it on the record. Its order dated 6/28/24 as it relates to the motion to withdraw to the defendant in open court. The defendant gave a statement and asked the questions of the court of his order. The defendant was provided a copy of the court's order hand-delivered on 6/28/24 by Officer Jones and Thomas. Now, we are reading this one right here, the order granting the motion to withdraw. So let's jump over there right away. And I apologize. Someone is mowing my lawn. I don't know who it is. Thank you, but at the same time, not right now. Not right now. Okay, here we go. Buckle up. This is absolutely nuts. It's crazy this is happening right now. On a Friday, of all things. Circuit Court, in the Circuit Court of the 9th Judicial Circuit, Orange County, Florida, This is the state of Florida versus Sarah Boone. Order. The cause came before the court on June 28th, that's today, 2024, on defense counsel Patricia A. Cashman, Esquire, motion to withdraw as counsel, filed June 11th. So 17 days ago, she filed the motion to withdraw. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman, Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds. Okay. Charges. On March 23rd, 2020, by way of information, the defendant was charged with second-degree murder. On February 26th, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, the public defender and attorney number 1, was appointed to represent the defendant. On March 9th, that was the following month, 2 weeks later, the public defender moved to withdraw due to defendant retaining private counsel, to wit, Mauricio, okay, here it is, Mauricio Padilla, Esquire, and the Padilla Law Group, also known as Padilla, and attorney number 2. On March 11th, that certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. So she's on number 2 right now, March 11th. On April 18th, Padilla moved to withdraw due to irreconcilable differences arising between the undersigned and the defendant that have been made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all the particulars to the court at the same time, maintain all duties to the client. This motion was served upon the defendant, and the defendant confirmed receipt. See letter dated April 20th and filed on April 26th. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of the hearing, Padilla had been representing defendant for 2 years. The defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant, a letter dated April 20th, 2022, and filed on April 26th, 2022, which seemingly objected to Padilla's withdrawal. That's Sarah objecting to her lawyer quitting. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3rd, 2022 to prepare and file an amended motion with a hearing to be heard on the week of May 9th, 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a lack of trust between herself and Padilla. I'm sorry, they're apparently only mowing the part right outside my window in my studio. Can you guys hear that? I can hear it through my headphones, so I know you guys can hear it. They'll be gone here soon. On May 4th, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds with these 2 lines. Undersigned's relationship with defendant has become adversarial. That means they're enemies. The aforementioned adversarial relationship has interfered with undersigned's counsel's ability to effectively represent his client, especially preparing for trial. And undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, the undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. He's saying, I'm not going to give orders. I'm not going to give the details. I'm not going to spill the tea on why we just can't work together. So on May 6, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds, saying the undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with Florida law and rules regarding regulating the Florida bar are present, or whether with the attorney-client relation has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of defense. The subnotes here say the same irreconcilable differences arising between undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all the particulars to the court and at the same time maintain all duties to the client. Grounds were included. The same irreconcilable differences, this is just saying what it's more specifically the language of what the objection was. On May 10th, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney, that he's number 2. The state expressed a concern of strategy to allow defense attorney after attorney to represent defendant. The court advised defendant that the state's concern regarding the strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. This is way back in 2022. The court appointed the public defender, attorney number 3. On June 6th, 2022, the public defender moved to withdraw due to a conflict. This is different. This is a legal conflict. On June 7th, the certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel and attorney number 4. On June 10th, 2022, RCC moved to withdraw due to a conflict. On June 22nd, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdrawal was entered, which withdrew RCC from further representation on the defendant and appointed Mark Counsel, attorney number 5. On July 8th, 2 weeks later, the Counsel moved to withdraw due to a conflict. On July 11th, that certain withdraw order was entered in which Counsel withdrew Counsel from further representation of the defendant and appointed Frank J. Bankowitz, attorney number 6. We know Bankowitz, right? On July 12th, 2022, so he lasted for, the next day, Bankowitz in open court requested a continuance due to his recent appointment, and the same was granted. Thereafter, the court set a pretrial conference for October 25th and trial during the trial period beginning November 7th of 2022. On October 25th, the court held a pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. On October 27th, Bankowitz filed defendant's motion to continue. On October 28th, the court entered that certain amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17th of 2023 at 9 a.m., and the trial during the trial period beginning January 30th. On November 22, the court set a status hearing on Tuesday, December 20th. We're going through the entire schedule. On December 19th, Bankowitz moved to withdraw the day before the status hearing due to irreconcilable differences which have arisen between the undersigned, his client, and his family, and the undersigned will be unable to effectively and properly continue representing the defendant herein. On December 20th, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing for December 22nd. On December 27th, the reset status hearing was held. Bankowitz appeared virtually, and due to the technological issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27th. On December 27th, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant that the court had received letters from the defendant, a letter dated October 3rd and filed on October 7th, a letter dated November 3rd and filed on November 7th, and a letter dated December 5th and filed on December 14th. The court conducted a Nelson hearing, and the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with the expert witnesses, including experts that Padilla, attorney number 2, had utilized. Bankowitz advised the court of the defendant's attempts to call Bankowitz at a rate of 5 to 10 times per day. Bankowitz further advised of his efforts to balance the demands of his other clients with the defendant's expectations for communications. In response, defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case rose to a similar level, and then sought to remove Bankowitz. The court pointed out the defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there was something defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with the defendant prior to the pretrial conference previously set for January 17th. The case was continued several times due to Bankowitz's attempt to retain an expert through Jack and JAC and JAC's response to the same. During this time period, the court had received several letters from defendant. A letter dated January 10th and filed January 17th, a letter dated March 22nd and filed April 14th, a letter dated April 6th and filed on April 14th, a letter dated May 15th and filed on May 18th, and a letter dated June 29th and filed on July 21st, and finally a letter dated August 2nd and filed on August 7th. On August 22nd, Bankowitz again moved to withdraw due to irreconcilable differences arising between the undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court at the same time and maintain all duties to the client. We've got references to the letter that has ad hominem attacks on Bankowitz's professionalism and morals. See also defendant's quasi ex parte motion for appointment of defense forensic psychologist and request for a sealed order e-filed, and the Justice Administration Commission's ex parte response to motion for appointment of defense forensic psychologist. The May 15th letter sets forth ad hominem attacks on the court, alleging that Judge Wayne C. Wooten was being monetarily compensated from third parties' use of the information that was publicly available. June 29th letter sets forth ad hominem attacks on Padilla, which were not raised during either the April 29th hearing or the May 10th hearing, on Padilla's motions to withdraw and set forth above. You've got more of that on page 4. See also, the defendant will not be satisfied with any attorney. It says this is continuing her Bankowitz's motion to withdraw. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his time or her time solely to Miss Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. On September 8th, a hearing was held on Bankowitz's motion to withdraw. The defendant was present in the hearing and was sworn. Bankowitz addressed the defendant's derogatory statements, i.e. dud and buffoon, and berating behavior. The court advised defendant that the court had received letters from the defendant with the following dates. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw, and he danced out of the courtroom. Oh, excuse me, that wasn't on there. No, and appointed Winston Hobson, attorney number 7. Thereafter, the court sets a status conference for October 30th. 2023, and set a pretrial conference for November 28th. After setting these dates, the court pointed out the deterioration of the working relationship between the defendant and Bankowitz. The court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. That was in a Judge Dad voice. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e. go to trial or testify. The court cautioned as to the defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel. On October 30th, the status conference was held. Hobson advised as to his conversations with the defendant and setting the status on January 24, 2024. Therefore, the court set a pretrial conference status as to the readiness for trial for January 16th and trial during the trial period during January 29th, beginning January 29th. On January 12th, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. On January 16th, the court addressed Hobson's motion to continue, granted the same, and set a pretrial conference for May 3rd, with trial beginning May 13th. On February 1st, 2024, Hobson moved to withdraw due to, you heard it, irreconcilable differences, including but not limited to ethical considerations. On February 9th of 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis of withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, the defendant's demands to make her difficult make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key substantive defense, Hobson advised that he retained an undisclosed expert and is not keeping with As to a key substantive defense, Hobson advised that she retained an undisclosed expert is not keeping with what the retained undisclosed expert is not keeping with what defendant has in mind. Okay, that makes sense. The expert's not doing what the defendant wants. The court advised defendant that the court had received a letter from the defendant dated January 19th. The court outlines the overriding claims for withdrawal by Patilla, Bankowitz, and Hobson: adversarial relationships, lack of satisfaction, inability to meet the defendant's desires. The court found that all the defendant's relationships with all court-appointed counsel have deteriorated such that defendant and the court's appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that the right is not unlimited. The court twice advised the defendant that defendant may not be provided another court-appointed attorney and that defendant would have to represent herself in circumstances similar to Hobson's motion to withdraw if they occur. The court further advised the defendant about the dangers of self-representation due to the defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court, she's our problem client lawyer. The court set a status hearing for April 12th. On April 12th, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7th. On June 7th, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present and for the hearing and was sworn. Thereafter, defendant advised the court to walking out of at multiple meetings with Cashman, which was confirmed by Cashman, utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, and providing the court with letters dated June 4th and June 7th, both of which were filed on June 21st. Cashman advised to her efforts and spent time on the case so far. And time spent on the case so far is 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be legally important. In riposte, defendant accused Cashman of lies and half-truths. The June 7th letter sets forth ad hominem attacks on Cashman's professionalism and untruthful answers. See page 8. The June 4th letter sets forth ad hominem attacks on Cashman's professionalism. See page 3. Both the June 7th letter, see page 8, and the June 4th, see page 2, confirm defendant disconnecting and or walking out of meetings with Cashman. On June 11th, Cashman moved to withdraw under the Florida rule regulating the Florida bar. Substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, and irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representation. On June 28th, that's today, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating the Florida bar and Schwab v. State case law as the basis for withdrawal. At no time has the defendant refused to accept the services of any of her 7 appointed attorneys. Law. Both the United States and the Florida Constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. You have the right to an attorney. There's the references. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. You have to choose because you have 2 rights that conflict with each other. Forfeiture of the right to counsel. Regarding the law, a defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. As set forth above, the defendant's recalcitrance, did I say that right? No. To the attorneys who were not conflicted out, Padilla, Benkowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, of Benkowitz and Cashman, and personal attacks on Padilla, Benkowitz, and Cashman, each of these attorneys were required to withdraw. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Wow. Wow, wow, wow. Additionally, the withdrawal of 8 different attorneys, 7 of which are court-appointed, leads to the determination the defendant has forfeited his right to counsel. I think they mean her. This is law still. Sorry. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. The case law says they found the misconduct in relationships with 4 attorneys, including verbal abuse, tearing up correspondence, refusal to cooperate in producing a witness list, and hanging up on counsel during a telephone conversation resulted in a forfeiture of right to counsel. So there's the case law. That's established. Furthermore, forfeiture of the right to counsel can be found through a pattern of serious misconduct, abuse, threats, or utter failure to collaborate in his own defense. Repeated abusive, threatening, and coercive behavior toward counsel can result in the forfeiture of a right to counsel. The court finds the defendant has forfeited the right to court-appointed counsel under Florida law. There is no obligation to conduct a Ferrata hearing or to otherwise warn a defendant of the dangers of proceeding pro se. The court can find, this is waiver by conduct. The court can find a waiver by conduct to the right to counsel. A waiver by conduct. So there are 2 ways you can waive it. You can waive it by signing and say, I waive the right to a speedy trial. I sign here. Or you can waive it by conduct. In this case, you can waive the right to counsel by conduct. And they're citing Sarah Boone's conduct as that waiver. That's her signature. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that the defendant be warned about the consequences of his conduct, including the risks of proceeding pro se. On February 9th, defendant was twice advised that another court-appointed attorney may not be provided. On May 10th, defendant was advised about the dangers of self-representation. On February 9th, sorry, I'm not reading the years. Those were 2022 and 2024. On February 9th, 2024, defendant was advised about the dangers of self-representation. As of February 9th, the instant case had been continued 16 times. That's how many delays we've had, 16 times. As of June 26th, this case has been pending for 4 years, 3 months, and 5 days from the date of the filing. Okay, stop. This is hilarious. The judge is counting the days. He has got so many letters from Sarah Boone that says, it's been this many days since I've had, and the judge sticks it in here, sticks it in bold and underlines it. As of June 26th, this case has been pending 4 years, 3 months, 5 days. He should have put the hours in there. From the date of the filing of the information on March 23rd of 2020. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in the efforts to prevent the resolution of the case on its merits. I think we've got Brandy Churchwell just did a raid. Come on in, 13th jurors. It is awesome. Please join us. We have an update on Sarah Boone. You're right at the end of this. We've been reading about 16 pages of this, but this is the good part. The defendant, defendant to persist in efforts to prevent the resolution of the case. So she's stalling on its merits. The defendant complains that Bankowitz and Hobson, two court-appointed attorneys, failed to meet and communicate when the defendant is provided court-appointed counsel who will meet and communicate, like Cashman. She still complains. The ways and means of meeting and communicating are unacceptable to the defendant. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. So the judge orders as follows. Cashman, her current attorney, her motion to withdraw as counsel filed June 11th is granted. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for cost to obtain transcripts and depositions for the two witnesses Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to the defendant, Sarah Boone, by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the depositions and transcripts were provided to the defendant, Sarah Boone, and such notice shall include the date sent and the address of the defendant, Sarah Boone. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Alternatively, Sarah Boone has waived by her conduct her right to court-appointed counsel. The trial management conference shall remain specially set for Tuesday, September 24th at 1:30 p.m. This case shall remain specially set for trial for the 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd. Done and ordered in chambers at Orlando, Orange County, Florida, this 28th day of June 2024, and it's signed by Judge Michael Kranick. Sarah Boone has lost her right to a court-appointed attorney. Now, does this mean that Sarah Boone is going to be pro se? Not necessarily. I would say most likely, but not necessarily. And the reason why, we back up here to the top here, the reason why is because court appointed is one, you have the right to an attorney, okay? But the state only has to court appoint an attorney so far. You can waive that right through your conduct, which she did. So the state says, we're no longer helping you with an attorney. You can get your own. Guess what she has zero of? It's cash. She has zero money to hire an attorney. So unless she has a wealthy benefactor or somehow manages to do a crowdfunding, which she's hinted at already in some of her letters, she will be by default pro se because the court is not changing the date. Even if she does manage to get an attorney, they won't stall. They won't give them any more time. So she is going to go to an attorney and say, hey, I'd like you to represent me. First of all, the attorney's going to be like, oh, yeah, Sarah, who? Oh, yeah, we heard about you. We heard about you. The lawyers talk about it, about the nightmares they've had. So Sarah Boone is not going to be able to find a lawyer easily. I'll put it that way. Possible? Yes. Easily? No. Because the lawyers will, be taking on that same responsibility that all the other lawyers previous to them could not handle, including Attorney Cashman, who was the specialist at difficult clients. Now she's on her own. She has no money. So we can expect another letter. We can expect some sort of fan funding attempt. That's the only thing available to her right now because she's said over and over she does not want to have her own attorney. But as it goes right now, we're proceeding. The dates are set. Court is happening. We're going to trial this fall, and she will be representing herself in trial unless she can somehow come up with a lawyer and convince him on him or her on short notice to take her case and run with it. Oh man, she's in trouble. She's in a lot of trouble, and unfortunately, the problem is she brought this on herself. Because every other lawyer before her, as the judge spelled out quite in detail, with a great deal of specificity, every lawyer before her has withdrawn for two reasons. Either there was a conflict, meaning I can't represent Sarah Boone because I'm actually representing someone else that's suing her or sued her in the past, or I represented her husband in a previous domestic situation. There was a legitimate conflict saying I can't be that person. Okay, legally, I can't. So either that happened, or her relationship with that lawyer just deteriorated so badly that the lawyer said, look, I quit. Not like I quit law. I mean, that's the next step, right? But I cannot take this case. And they begged, in some cases, repeatedly to get released from her, from representing them. Attorney Cashman comes along, and she's amazing. She's like the perfect lawyer. She is not only extremely skilled and experienced in the very field of law that Sarah Boone needs the most help in, which is murder defense, right? But she's also great with handling tough clients. And the judge knows it. They assign her knowing that she's like, look, this is the one. If there's any lawyer that can handle this, it's Attorney Cashman. And Attorney Cashman has to eventually, after trying unsuccessfully, has to eventually say, look, I can't. She won't let me represent her. I'm meeting with her, and instead of saying, hey, you're not meeting with me enough, I'm meeting with her, and she doesn't like the way the meeting's going. She doesn't like the tone that the lawyer has with her, or the direction that she's taking the case, or how she feels best that they should proceed. And so Sarah Boone invents in her head this fake judge, right? She said this in her last letter. She's like, every time Attorney Cashman comes, we pretend there's a fake judge. And I'm like, remember, you're in front of the fake judge, so talk to me as you would in front of the judge, not as you are right now, which is being rude. Attorney Cashman's like, I don't need to put up with this. I shouldn't have to put up with this. And she's right. She doesn't. And the court sided with her. Sarah Boone is now on her own with a pending, looming court date that, even though it's been 4 years, she is not ready for. She cannot handle this on her own. It's nobody who is not legal, even lawyers should not handle their own murder trial, right? If they're being tried for murder, you want somebody else to handle. There are too many moving parts and pieces. This subpoenaing witnesses, cross-examining people, calling witnesses, just trial strategy in general, working with the different motions in court. Just being able to make a motion of proper timing to the judge that has the proper, request for relief and everything in it, so the judge can even consider it. This is hard work for anyone who's not, skilled in this area. Oh my goodness. It's beautiful. It's beautiful because it's moving forward. She finally gets her day in court, and let's see. Let me see where we are. I've been ignoring chat. I apologize. What are your thoughts on this? On what's happened so far. I've got a couple messages that I want to hit really quickly. Holly Mack, welcome back to the gallery. Love the Orange Courthouse by your name. Thank you. Dina Do, 420. Love RA in this whole amazing community. Sarah Boone, hot mess. Can't wait. 13 months. Thank you. Appreciate it. Sussex Sandra says, Boone brought this upon herself. What's that saying about a person who represents themselves as a fool for a client? Now, think this through, okay? Just logically let this play out in your head. Sarah Boone, I have fought like mentally and verbally on the channel. I've said she deserves her day in court. The longer this gets stretched out, the more she deserves it. The judge sees it differently. The judge sees that Sarah Boone's been the cause of the delay. I was giving her the benefit of the doubt, but she does deserve her day in court, especially if she didn't file a waiver of speedy trial. But now it's going to happen, and now she's ready. So imagine her appearing in court. She's not sov sit, okay? So we don't have any of the Darrell Brooks mess that's in there. But prosay is still a challenge for the court. The judge is limited. He's got his hands tied in what he can do. He can't help her through her own court case. There will be points in the trial where I imagine that he will spell things out a little more slowly and a little more detail and explain the options more so than he would to an attorney. But generally, he just has to leave her on her own. She's up a creek getting a lawyer. It's just not going to happen. Now you have her who's going to consult with herself on the decision to what? Testify. She's going to talk, and that can't be good for her case. She's wanted to talk from the get-go. She's wanted to just explain to everyone how it was unintentional. She's going to get up there on the stand, and it's going to be a circus, absolute circus. Dream of Laundry, member for 11 months. Love and miss y'all. Good to have you here. Welcome back. Gally May, member for 14 months. What a day. Thank goodness for Sarah Boone today. I needed a mind reset. Love you, RA mods and the addicts. Thank you very much, Gally May. 14 months. Is the whole trial going to be her reading 1,000 pages of definitions? She has that down. She's been studying the law, or at least copying the law, this whole time while she's been in jail. So maybe that gives her a slight advantage. She said in her last letter she is competent. Jeannie B, yes. Holly Mack, member, 12 months. Woohoo! 1 whole year. It's been great. Thanks all. Holly, congratulations on 12 months. Love the Orange Courthouse. Thank you so much. Box Fort. Sarah Boone has complained and said that there are not enough, there isn't, all her material for court is not there. Because of all the different lawyers she's been through, she thinks pieces have gone missing. And I think the court thinks otherwise. But she thinks there should be more there than there is, and things are missing and maybe she just doesn't know where it is. But it's she now is going to have all the boxes delivered to her, and she will have all her evidence, and then it's on her to prepare her defense. Jamie, member for 10 months, says you love it here. Missing R80 and the KR fiasco. It's almost over. Jury's going to be back on Monday is what I hear. So we'll see. I can't wait. I want to watch the verdict with Brandy when that happens. Let's see. This this takes her case. It's already been a high profile case, but this adds that prosay element, which is always a huge draw publicly. There's going to be massive media coverage of this trial now. It's going to be huge. It's going to explode exponentially, bigger than what it was before. So you are going to see this on Court TV and Law and Crime and obviously Top Mark Media and everything else, where everyone's going to be there requesting access and following along. It's slated for a 2-week trial period. I don't know if it's going to take that long. It probably, with a pro se defendant, might only go 3 to 4 days. Would be my call on this one. There's just not that much there. It's not like we have cell phone pings and records and maps and loads of cameras and things to go over. It's a pretty narrow window of time that we're looking at. Are any of these attorneys allowed to talk about what's going on? No, that would be improper for them to go out and start speaking about a prior client, and you won't find any of them doing that beyond what basically they can file in court. But let's see, where else we have? Laura Fry, so glad your show is so great. Thank you, Laura Fry. Appreciate it. Member for 1 month. Appreciate you. Love the blue courthouse that changes color over time. It's there by your name. Christy G says, love my RA family. Thank you so much. DMB second, this is in the house. Recovery Addict. If I see her bring a dictionary to the trial, I'm going to cry because we all know she'll be reading half the thing into the record. The judge is not going to allow the delays. You can see already that he's had enough with that. If you guys are not up to speed on the latest from Sarah Boone prior to what happened today, last week we read Sarah Boone's 58-page hand-delivered letter. It's a doozy, but you can find it on the channel here. You can go back in the Sarah Boone playlist, and you can see all 58 pages. The last 30 pages or so of that letter, the first 20 pages ish were complaints about attorneys and everything else. But the last 30 or so pages was her copying stuff off the law that she found online, copying definitions out of a dictionary that she thinks might be beneficial for the judge in ruling on her letter, which is not a motion. It's just like a letter to the court, which has to be stamped, received, and filed. But it was wild. Michelle's Mixed Media Madness. 7 months. Best day to celebrate my 7 months of membership. I'm here for it all. Gail Pett, I'm sorry I missed your 16-month milestone this morning. Congratulations on 16 months. I apologize for missing that. I try my best not to, and clearly I failed you in that regard. And I take ownership on that. I'm sorry. Okay. I did come in when you read that. She's going to read taint into the record. She is. Taint is one of the words that I read it into the record. It's in her letter. What's the chance of her getting an attorney that wants the press? Karen, this is an interesting idea. Because you can think there are some people out there who, for them, any press is good press. And there's a small chance you're going to have to find somebody who's licensed to practice in Florida or can get, approved to practice in Florida on short notice. But what would be the benefit to them to do that? What type of client are they seeking that would see this and say, yeah, that's the one I want, right? I want the guy who, or the gal, the girl, the lady, who I want the lawyer who really takes the difficult case and, I don't know, and doesn't get paid well for it, that does it pro se. There's a chance there might be somebody who wants the press, but I just don't think so. She is so difficult to work with. She's proved it over and over. She's going to write a letter. Yes, there will be another letter between mark my words, between now and trial, there's going to be another letter, and it's going to address this issue with the court removing her right to have an attorney. Joe, Ohio, welcome to the gallery. Like that yellow courthouse. Congratulations. Thank you for at least 6 months of support there. Can you imagine the letters we'll get now? They're coming. They're being written as we speak. Peter Tragos is not going to. Tragos Law is not going to be representing her, but I think Peter has said he's going to be in court, which is cool because I might go down there as well. You never know. Let's see. I've just joined today's chat. What date is the court case set for? The court case, Sarah Boone, is going to be. Let me pull it up here. The date is begins October 7th, 2024 is the date. There's a pre-trial trial management conference September 24th. So September 24th is the first date, and then trial starts October 7th. And the judge has said, and will not be continued for any reason except by extraordinarily good cause, which means no, don't ask. At this point, all of her letters will have to be considered as their emotions, if there's anything resembling emotion in them. No, Lane, I don't think so, because she had representation during the letters being sent, so I don't think they go back and then view them as motions. Moving forward, I think the judge might be a little bit more forgiving on the format of any motions that are received. For instance, they're going to be handwritten, which he wouldn't allow an attorney to do. But a handwritten motion that might not be entirely formulated correctly might be accepted still. Let's see. Pro se means represent oneself. Pro bono means for free. Right. Pro se, she did not want to be pro se. She said that over and over. She does not want to represent herself. She wants an attorney, but she wants an attorney to represent her the way she wants the attorney to represent her, not the way the attorney has. And the judge has told Sarah that you don't get to choose everything in your defense. You don't get to, it's not one player playing chess and the lawyer is one of the chess pieces. But the lawyer looks at everything that's set before them, the facts of the case, the evidence, the testimony that's going to be heard against you, and they say, based on what we have, here's the best defense. This is what we can go forward with. And aside from whether or not you plead guilty or not, there's a lot that the attorney gets to choose there. Attorney does not get to choose whether or not you testify in your own defense. Sarah Boone's always going to have that right, whether she has an attorney or not. And now that she doesn't have an attorney, she doesn't have anyone to reasonably talk her out of wanting to do that. Okay, let's see. Sarah Boone forfeited a right to counsel, to court-appointed counsel. That means a free attorney provided for you that the court lines up. She can still have a lawyer. And so the next letter, I think we're going to find that a reference to this. She said this once, 2 letters ago. She said this, that she thinks that she could, her fan club, because she does get fan mail, would start some sort of a fundraiser, like a GoFundMe, for her defense. And so that might be used to, I think she was suggesting it for an expert witness, but now she would have to find it to pay a lawyer. How many times, if any, will Sarah state in her next letter she does not want to represent herself but is being forced? Oh, that is good, the narrative. That is the narrative, Laura. You've twisted my arm. You've taken away my constitutional right. None of this was my fault, right? That's a common theme you've seen throughout all the letters. Will her ex-husband step in to help her with getting a lawyer? I don't think so. That's just a tough situation. I mean, he lives close by or lived close by to them, but I think he got out for a reason. I don't think he's trying to rekindle anything there. Let's see, can't wait to see her next letter. Wow, she's probably already writing it. I agree. It probably started being drafted as soon as she got back to her cell after this hearing. Hard to believe a lawyer could get up to speed fast enough to represent her, even if they wanted to. Yeah. We're in the end of June, July, August, September. You've got 3 months to get up to speed in a murder trial with a very, very difficult witness. GoFundMe doesn't do that anymore. They won't do lawyers. I've seen that. There are some other crowdsourced fundraiser that do allow legal defense, but I don't think they're any of the big ones. When Sarah Boone complained about not getting medical records, she was actually talking about George's or hers. She probably will need both. It's going to be difficult. If the state has it, it should be turned over in discovery, especially if there's anything that might be useful for her in defense. But she's going to have everything her lawyer has. Apparently, there are 2 boxes that are going to be turned over to her, as well as the copies of the deposition of the 2 people that her most recent lawyer, Attorney Cashman, deposed. Let's see. We're all responsible for our behavior. She wants to dictate to a lawyer. She could afford a lawyer if she didn't spend it all on paper, pens, and stamps. No, I don't think so. But just remember, it wasn't deliberate. Definitely will have that on your bingo trial card. Let's get John Pryor to do it. No, I don't think he will. Laura says, I don't think she's unrepresentable, but she needs to manage her expectations of defenses. To this point, Laura, she hasn't successfully done that. I will say, to her credit, specifically with Attorney Bankowitz, when he was representing her, it did appear that she wanted to meet with him, and he just didn't meet with her, period. There were periods of time in that representation that seemed to be less than the bare minimum that an attorney should meet with a client. And yes, Sarah Boone was right. That Attorney Bankowitz had been reprimanded publicly previously by the court for failing to communicate with a client. So she might have had grounds for that one, but she didn't make it any easier for her part either. Allie B from Tennessee says, I'm a replay crew. This is interesting, but I figured this would happen. Is it not possible for her to have assistant counsel? Sarah, she can. The problem is she now has to pay for them, and she doesn't have any money. She's said before that she couldn't afford anything, that she need. Well, she's indigent, right? The court found her indigent. She doesn't have enough money to pay for her own attorney. That's why she qualified for a court-appointed attorney. Now she no longer has that option, and she has to come up with both the money and the attorney in 3 months. Let's see. We do have a playlist. Thank you, Samantha Terria, for the link, the playlist at the top of that. If you've missed any of Sarah Boone's letters and want to go back and review them, we've read every single one of them in as much detail and accuracy as we possibly can. She has had some legitimate gripes. It sounds like the court is not buying the delay one at all. Problem with Boone is she can't see past her own arrogance and narcissism. She has some personality traits that are going to make being likable and being believable in court difficult for any jury. Preserving the record, she's getting what she deserves. It does seem like, there's a little bit of justice happening here. Okay. Veronica, I'm late. Hold on. She's going pro se. Yes and no, Veronica. We don't know for sure that she is going to be pro se, meaning that she's going to represent herself in court without an attorney. But we do know that the court has released her current lawyer, Attorney Cashman. As soon as Attorney Cashman sends those depositions from the last 2 people she interviewed over, she's done. She's out of the picture. She sends the boxes of evidence over, and she washes her hands and walks away, probably happy with a smile on her face. But Sarah Boone now gets to choose, does she go pro se and represent herself, or does she hire an attorney with no money? And that's going to be difficult. That's an uphill battle. Boone is her own worst enemy. She's been acting sort of contrary to her own interest. Just writing the letter to the judge alone is not a good idea, because it is public record, and as much as she complains about it, it's public record, and she's used that to get her message out So I think she's trying to play both sword and shield with that. But she's also accused the judge of making money off selling her, her legal documents, which Florida's a sunshine state. You can practically find anything you want. Lots of things you probably shouldn't find, you can find for free online because Florida is just wide open that way. Let's see. I think after knowing she doesn't have a lawyer, Sarah might just give up and become self-harming or in need of psychiatric treatment. I don't think so, Patty. I think she's told herself a scenario so many times that she believes it herself. For starters, she is her own biggest fan as far as this goes, and I don't think she could see more. I read most of the footnotes. There are some nuggets in those footnotes as well. They reference a lot of the previous letters, and every letter is referenced in there by the judge. But for me, personally, when you look at this letter, let me scroll through and show you. The best part that just screamed, I'm sorry, I'm going to scroll a little bit fast here, so just 1 second here. Where's my mouse? There it is. The best part for me is when the judge responded, because you remember Sarah Boone's letters, many of them counted how long I've been in jail. It's been this many days since my attorney called. It's been this many times I've tried to reach him on the phone. This many times I've written a letter. Right here, part AAA. As of June 26th, this case has been pending 4 years, 3 months, and 5 days. This, you know he's got a smile on his face as he's doing the math and writing this in the letter, because it's just right back at you. We're sick of all this that you've been throwing at us. But anyway, it's going to court. It's moving forward. A little bit of judicial snark, but at the same time, it's not inappropriate. It's citing a fact and saying, we want this to move forward. We want your day in court. It's been too long. We do cover everything Sarah Boone related, so that's what we do here. Let's see, any other questions we can answer on this? I think the second-degree charge is the deal. Yeah, she's being charged with second-degree murder, so the worst possible sentence, if she got the maximum penalty, would be life in prison without parole. And she's, by her math, she says she's been in jail for over 5 years, but clearly, by the judge's count, that's a bit of a stretch of the imagination. But Flux, I think the big takeaway from this, other than that this was inevitable, right? A lot of people have looked at this. It's been teased that she would be pro se, that no attorney can handle her. Her own attorney, Mr. Bankiewicz, when he withdrew, he said, the best thing for her is pro se. Judges have said, hey, if you keep burning through attorneys, you're going to end up pro se. It's been teased out there for quite a while, so we knew this was coming. But now there is no more delays. We've already got in the judicial record that the judge will not allow for any delay, even if at the last minute, in the 11th hour, which we're almost in right now, she somehow manages to hire her own attorney to represent her, which I hope she's able to do, because any attorney representing you is probably going to do better than her representing herself. Can the judge question the attorneys about why they quit? Yes, Pale Rider, yes, and he has. Actually, we've got two judges. We've got Judge Wooten, and then we've got Judge Kranick, because the case changed, was assigned to the other judge. And both of them have, to some extent, requested information about why attorneys were trying to quit. But in almost every case, other than that, irreconcilable differences, unethical, ethical considerations, other than those sort of blanket terms, they haven't been details shared. And at the best, they would say, Bankiewicz said it was something a conflict with his family and representing Sarah Boone, which probably was a reference to the amount of time he calls her his personal cell phone. But other than that, we just don't know. Just the unrealistic expectations was probably the biggest one. Kaylee, you're going to attend. You're only an hour away. That would be great. All right. Is this the most lawyers afforded to an accused person that you've seen? The most that I've seen, but I'm not sure if it's a record. There have been a couple cases where there have been a lot of lawyers. I think there's actually one that... No, there is another case. There was a gentleman that had more lawyers than Sarah Boone. Just a crazy guy. Crazy guy. I was promised a Sarah Boone trial for my birthday, left me with a legal letdown, so I hope it goes forward this fall. Like in my briefs, I think it will, for sure. The judge is not allowing this to move anymore. Brandy Churchwell's going to go. I would love to meet Brandy there. This might be a good reason for me to get down to Florida again. Is hating your client a valid ethical reason? Connie, I don't think any of them hated their client. They might have really hated her behavior and what it did, but let's see. Hope this will be streamed. It will. Susan, this is most definitely going to be streamed. Now, we're still working on the court to get our pool media access to the trial coverage. So because we want to be there in the courtroom, getting the feed for you directly instead of watching it through somebody else. But we're still working on that. Hopefully we can get that lined up in time. How is this possible? Sarah Boone is a straight A student. She excelled at everything she does. Brandy will be there in person. It would be awesome. I've never met Brandy in person. She's amazing. We've been on many live streams together, but that's it. Let's see Dr. Joe again. Do you think Dr. Joe would? I don't think he would come up for this one. This is not his cup of tea. Let's see. Please don't delay the stream of Boone's trial. Nothing's going to delay the stream. It's going forward. We do have a trial date, Flux. It's set for, if you can mark your calendars now, the judge said the trial date is moving forward on October 7th. October 7th. And there's a week or two prior to that, September 24th, there's going to be a trial management conference. And probably both of those are going to be televised. Okay. A new channel talking about Mrs. Boone. Very excited. We have followed Sarah Boone and all her letters. We followed a lot of this case. We followed her interview, the dash cam, body cam footage, jailhouse interrogation, and all the happenings that have, with the lawyers and the exchanges of the lawyers as they've rotated through for quite some time. We will stream it on this channel. We'll probably also stream it on Top Mark Media, on my media channel. So this was a hearing. Wonder if we can get footage. Valkyrie, this happened. This was secret. We have been, and I say we, both myself and a lot of our mods, some of our document hounds, have been watching the Sarah Boone docket religiously every day, multiple times a day, to look for any updates, because we were expecting, with the judge, with Attorney Cashman filing off that motion to withdraw, we're expecting a hearing to be scheduled at some point. It never got scheduled, at least not on the docket. It never got put on. So it did fly under the radar. Obviously, if you were there in court that day, you probably saw it, but I don't think anybody had time to get a camera in there. Let's see. Thank you, Samantha. That's the Top Mark Media is my other channel where we just air trial footage, where if we have cameras in the courtroom or if we're linked up to the feed and through our own live view and sending it out, that's where you're going to see it. And that's also where we share it with other content creators who want to use the content for their own live streams. Gonna need all 8 attorneys to sit in the pews with popcorn buckets. I seriously think every single one of them is just glad to be out of it, just walking away with a smile. Poor Attorney Bankowitz, it just about killed him. I mean, it was rough. Or was that Hobson? I think it was Hobson, who was literally, he was on his deathbed, just begging to be released from the Sarah Boone case. Former attorneys selling popcorn inside, hot dogs and food trucks out, their way to recoup funds. I think they all got paid because they were court appointed. They got paid for their time, but they get paid for the time they put into the case, not the time that they got harassed over the phone. Jamie Lunas, this is true. This is true. We're looking at the order right here, just filed by the court today. It's hot off the press. Look at the timestamp. It was filed at 2:47. So just this afternoon, it's fresh. This was a hearing that the judge had with Sarah Boone and her counsel, Patricia Cashman. Patricia Cashman had asked to be released after Sarah Boone had handed the judge a 58-page letter in her last hearing. We read that letter in its entirety on the channel, so you can go back and watch that if you want. And you can watch we read every single letter before then. that she's written, and this one did not disappoint. It was full of accusations and finger pointing and complaints and definitions, legal definitions, tons. So I think she knew this was coming. Let's see. No verdict. No verdict in the Karen Reed trial. It's going to be at least Monday before that comes back. Dog Mom says, Ladybird, I just really hope that this judge does not let her get an upper hand in this courtroom, because this is horrible for the judge, poor George's parents. Dog Mom, this is interesting, right? We have seen pro se defendants that are unruly, and usually they're the ones that are more sauve sit, that want to control the procedures at court. Sarah Boone is not a sovereign citizen. She is able to work within the confines of the court system. That's one of the things she prides herself on. She's like, I do excellent at everything I do. She just needs to know how it needs to work, how, where, what, and how many, right? I think that's her line. So I think she might surprise us with how well she's able to put together at least the basics of a defense, or gain understanding through the procedures as her court case moves forward, especially in cross-examining witnesses and asking questions that can be admitted in court that aren't leading of witnesses. It's going to be crazy. Mathis agrees. Better call Saul. Yes. She has a 2-box fort. She has 2 boxes of evidence plus 2 more depositions. Let's see. Lexi says, "Here's me finally getting to check to see if there's a verdict, and I saw this and am shook." It's a surprise that it came in on Friday, but the end result was sort of inevitable that this happened. But the judge, the telling part was the judge didn't even say we think that we need to sit down and tell her. It's like, no, we've warned her, and he gave the dates. This is the date we said. If you keep doing this, you're not going to have a defender. You're going to be pro se. If you keep here are the challenges you're facing if you go pro se. And she said she didn't want to be pro se, but she kept on the behavior that the judge says, you have waived by behavior, by your actions. You've waived your right to an attorney provided by the state. Now you're on your own, and she is truly. What this means is that you may see people calling her, news specifically. You might actually hear people calling and talking to Sarah Boone and getting information from the jail. I'm not sure what the jail's rules are on that, but without a lawyer to represent her, there's no go-between, and she might try to get her message out, rush to the pulpit, as she says, any way that she can. She's not SovSit yet. That would ruin everything. I mean, SovSit is just terrible. I don't think she will be. Jen, welcome. Yeah, we weren't going to go live again today. We thought we were going to get an early weekend, but then this dropped just at the last minute. Let's see. If it's pro se, how does she help pick a jury? She does, in person. She gets to sit there, probably not in jail clothes, because any appearance of being incarcerated could be deemed prejudicial in the minds of the jury. So she gets to wear street clothes and sit there in court and ask questions of juror members. Usually that's not televised. Usually. I'm not sure if it will be in this one, but I think it would be pretty easy to find a jury. She thinks it's impossible because everyone's heard about her case. I don't think that's so. I think a lot of people have not heard about her case. She does realize calls are recorded and can be used against her. Yes, and her letters that she sends out are copied and can be used against her as well. I think she's slightly brighter than that. I think she has more to offer brains-wise than we've seen. The writing the letters and stuff like that, that's not the best she has. And I think we might see moments of brilliance, or at least moments of more higher levels of effectiveness than we've seen so far from her. So she's representing herself. Megan, right now, yes. The judge has ordered she no longer has counsel. They have released her lawyer, and she does not have another lawyer. So currently, in the books, in the law, she is representing herself. She may still get her own lawyer, but she has to pay for it. on her own, out of pocket, and she has no money. She doesn't have income. She doesn't have a way to pay for that. I doubt she can, promise a book deal, because those sort of things generally, it gets into the Son of Sam stuff. But I don't know how she could pay a lawyer right now, other than somebody who decides to represent her pro bono. But generally, I would expect a pro bono in a death penalty case, maybe even a wild one like that, just by somebody who is morally objects to a death penalty. But hers is second-degree murder, and that's just life in prison. It's a lesser sentence, so it doesn't even draw that crowd as far as the pro bono lawyers go. Will she get a computer or be subjected to the regular 50-page handwritten motions? She has a computer system, some sort of tablet system that's offered through the jail, and she has been using that for research for some of her letters. She also uses that to access the court filings the same way we do, and she also uses it to watch us on YouTube. I have a feeling someone will step forward to help her. It would be nice if they did. But you've got to realize they might not be able to. If she insists on behaving this way, they might ethically have to withdraw, like her previous lawyers did. I'm not sure if you can represent her the way you should, and do so ethically. So, the lawyer has to be ethical, but you're going to be fighting against your own client in representing her. Can a GoFundMe, as far as the GoFundMe brand, I think they no longer allow for fundraisers for criminal defense. That's my understanding, but there might be some other give, send, goes, or I don't know which ones will do it. I could see you're questioning yourself on the stand. So funny. Lily Wayne, in the times that does happen, the judge will usually make an exception to that and allow the defendant to get up and just speak in a narrative form about what they want to talk about, instead of having to ask themselves questions and then answer the questions. Although it might be smarter for Sarah Boone to say, no, I'd rather ask myself questions just so I can stay focused and not go off on the narrative. Was representing herself intentional? It looks that way. Vern, I don't know if she watches this channel, but she has watched other channels and has aggregated total watch hours or total watch times or counts based on how many times different things have been viewed. So I don't know specifically if it's this channel or others. The real question here is, should our counter be not intentional or legalese? What would the counter be for court? I could do a not intentional counter. With the prosay, I don't want to do a legalese counter on this one, but a prosay one, I'd probably do not intentional. That would probably be a good one. You can fundraise on GoFundMe for defense of non-violent crimes. Violent crimes aren't allowed. Thanks, Abe, for the clarification. I appreciate that. I think murder would be classified as violent, even if the method of murder may not have been, well, may have been violent too. It's probably ruled out either way. According to herself, she has lots of fans in South Korea. Why doesn't she ask them to pay for the defense attorney in America? This is what I think she'll do. And Mel, this is why I think we've got another letter, and it's going to be coming very soon. Sarah Boone, the only way she can speak to the masses is by writing to the court. And she knows this is working because in her letters, she's addressed the masses through her letter to the court. So she has a free trumpet to the world, okay, to get her message across any way she sees fit. So if she is doing a fundraiser, I think she's going to put it out that way and try to get people to respond and help her. The problem is the clock is ticking. Okay, with it being the end of June right now, you've only got a couple months before trial begins, and you have to set up a fundraiser, gather the funds, have the funds pay out, and then hire a lawyer. The lawyer's going to be coming in the week before trial, and it's going to be crazy. Let's see, Law and Lumber, FNF tonight. It's always a definite good watch. If you don't follow Rob on Law and Lumber, you should. That's a fun show every night. Usually goes much later than I can go, but We've got a lot of people in here, so we turned on slow mode. Please don't take that as offense. It just allows us to view some of your questions a little better and not have them scroll so quickly on the screen. Let me see what I can get to. If you have a question as well, if you can tag me like you're doing here with just the @ symbol and Recovery Addict in it, that will show up in orange on my screen. I'll be able to answer it a little better. You know she's writing a letter right now, 74 deeds. I think she is. Okay, but do we do verdict watch clocks? Can we do a Sarah Boone letter watch clock? The problem with the Sarah Boone letter watch clocks, as open as Florida is, Laura, which is great. Every time she files a letter, it gets filed and we get to see it. It sometimes takes a week to, in this case, like 17 days from when it was filed or handed to the court to when it shows up on the docket. So things can take a long time. Usually it's at least a week turnaround time. She needs to consider that in her fundraising efforts. Couldn't pay me enough to represent her, even if I was a lawyer, says Sherry Smith. Yay, Rob. Can't wait for FNF tonight. Thank you. Janelle Silver, welcome to the gallery. Love the Green Courthouse. Thank you very much. Appreciate your support. There has to be an attorney in here that will defend her. I think there is, but they have to, look at this. They have to be available. So you've got to have an attorney who basically has no workload, because taking on a murder case with 3 months before trial is going to take a lot of your time. You've got to be a Florida attorney, licensed to practice law, and capable to defend a murder charge. There's a lot of pieces that have to fit together. So even if you check some of the boxes, if you have a workload right now with other court cases that interfere, the judge is not moving this case. He's not moving the trial. So it makes it really, really difficult for Sarah Boone. I have a vision of her standing, asking herself a question, then running up to the stand to answer it. Peter said, no way, says Kelly. I think Peter is right in doing that. I'm guessing this will unravel at pretrial, as clearly as how she's trying to defend herself is not ethical and that it's not going to fly. John, I think the judge dotted his I's and crossed his T's on this one. The Florida law and the Constitution, these rights are not absolute. You can lose the right to something that you're normally guaranteed the right to do based on your behavior, and the judge cited that. They have case law examples of when this has happened, and this is the spitting image of the case law. So the judge is on solid legal footing for his decision already. Yeah. Let's see. Lindsay's like, OMG. I just saw the title. I wanted to say Sarah Boone goes pro se, right? And maybe assistant counsel. Gene, I hear that. That would be like standby counsel, or having a lawyer sort of whispering behind you, but you're doing all the work. You still have to pay the lawyer, and it might be cheaper, but I'm not sure. That was buffer sound means. Mods have something to say. Amber says, Recovery Addict, with so many new faces joining us for this breaking news, can you do a little intro about you and the channel name, please? I'll do that here in just a second. Let me answer a few more questions, and don't let me forget who we are and what we do. I still can't believe the case law was only 4 lawyers, and she's had 8 appointed. Yes, she's basically an extreme version of this. Your thumbnail does say Sarah Boone is going pro se. I did. Well, she's pro se now, so I'm not lying. I guess that was a little bit clickbaity, and I apologize for that. When I was making I made the thumbnail first, and then I made the live stream. And so she's pro se at the moment. She's representing herself. All she had to do was unzip the suitcase, and possibly not roll it down the stairs. And there's the whole possibility of it getting hit with a baseball bat as well. A recap for Steve. I will do that. And first, let me welcome everybody who's new here. I go by Recovery Addict. My name is Scott. I'm a true crime fan. I love this. This is what I do all day, every day. We started doing. I started following court cases live on YouTube with the Darrell Brooks trial, and loved it, and have been here ever since. We followed some very hard cases, some really funny cases. We follow some of the lighter notes in court. We follow some police chases. We followed the Cavalcante manhunt up there in PA. We followed Brian Kober's plane across the nations. We helped pinpoint which plane it was, and found him getting shipped back to Idaho. We follow a lot of legal documents in some of the big cases that are coming up. Corey Richens out of Utah, that's the fentanyl poisoning. Sarah Boone, obviously. Brian Koberger, we followed the hearings and everything that's happening there. All that. I'm a tech guy. As you can see, I over-engineer my studio. I love technology, and so my interest is getting the video to you. So we do have all the equipment that a lot of the big channels have that are able to go to court and send out a live view, and take a bonded cellular encoder down to the courtroom and plug it in and bring video back. We've done that from the Maya trial. I've connected to the courtroom there in Sarasota and live streamed court from there. That's what we do, and we love it. We run a fun channel here where we're all interested in the law, and we just treat each other respectfully. And different opinions are welcome. We just ask everyone to be nice. And at the end of the day, even if we disagree, we're still friends. The name Recovery Addict for the channel, I chose this name when I was trying to start a YouTube channel focused on metal detecting, which is one of my hobbies that I love. And I found out that nobody wants to watch my metal detecting movies, and that's fine. So I stopped doing that. But I did start live streaming court cases on this channel, and the name stuck. I do have a personal experience with addiction and being in recovery. I was addicted to computer games, and people look at that and say, yeah, that's not an addiction. I just about lost everything. There was a time when I was driving down the freeway at 70 miles an hour, and literally with a laptop in the car next to me playing a computer game because I could not stop playing. With the help of family and some supportive friends, I'm in recovery now. I don't play like that anymore. Occasionally I get to play a little game with my kids, and that's about it. But I love what we're doing here now. So we've kept the name Recovery Addict. We do support people who are in recovery from addictions of all types, and we'll see a lot of time people celebrate and share their successes and relapses here in chat. So that's why we have that name. We do respect the process and that everyone's going through as they search for their own path to sobriety. Metal detecting, yes. I've metal detected for the police. My personal experience, I have a degree in communications, electronic media. That means I run cameras for everything from NCAA basketball, football. I've filmed for the police in ride-alongs. I've filmed for community television and race car teams and everything else. I love cameras. I love tech. I try to bring that to what we do, and it allows me to bring out a little bit different presentation than what you might see other places where we have, for instance, I'm just building a replay system so we can do instant replay of things that are said and slowed down. And when videos are shown in court and we want to see details, I can present that to you immediately. Because of some of the equipment we have. So that's a little bit about me. We have a awesome community here. We have amazing mods that are just amazing. They're fun. They love the same sort of things you do. If you found this court case and said, Sarah Boone, I've heard about that one, you'll love it here. So please click the subscribe button. We would love that. We'd love you to join every work day. We go live, usually about 8:45-ish, for about 8 hours a day. And live stream court cases from around the country and talk about them and share experiences. And sometimes we do a little bit craziness. We also have a podcast that we are on this channel every Thursday night that we call the Not Relevant Podcast, because we take a break from all the stresses and sometimes the heavy things that we cover in court to talk about things that are a little bit lighter and have some fun. Thomas, who goes by Weatherwatch in chat here, is my podcast partner there. So that's the background on where I am. Any more questions as far as Sarah Boone? The breaking news, if you just joined us late, is that Sarah Boone has lost her right to counsel provided by the state for free counsel. She's not going to be represented by a pro bono, or I guess pro bono would be wrong. Pro bono is working for free. She's not going to have a court appointed attorney. She can still hire her own attorney, but she doesn't have any money. So that's going to be a tough go for her. Trial is set for her on October 7th is the beginning of trial, Debbie. I want some metal detecting shows as well. We might do some. We've got a holiday coming up next week. I might go to a beach and do a live stream metal detecting. Debbie Facing Cook says, I only have 188 subs last I checked. What's your channel about, Debbie? Maybe we can send some more people over your way. My new addiction is courts. Who said that? Gamer Lover. Yes. It went from games to courts. I appreciate that. Courtney Alero, our Leo, excuse me, Courtney, I always mess up your last name. RA family is where it's at. Welcome all new family members. Thank you very much. You'll find this community is different than almost anywhere else you've seen on the internet. The only other place I've seen the amazing community we have here, both in generosity for gifting memberships and everything, and just in kindness, reaching out and befriending each other, is in other LawTube channels. There's something about this community that's just great, and I thank you, each of you that bring that and create that here. Did he mention that you've been filming in the courtroom for a post-trial hearing for Maya? I was down there for that. We've done that. I've worked with media outlets. I've consulted with media outlets for coverage. I have all the equipment. I have pan-tilt zoom cameras for setting up in court, microphones, everything. So we're going to be bringing you more of that as down the road. Right now, it's really easy for us to just send a live view bonded cellular encoder to Park City or to wherever, Florida is where I took it last time for the Maya trial, to connect to a live feed from court and share that with y'all. But do you think Boone will pick up law quickly like the accused did? The accused was pretty quick. That was Mr. Judge McBurney in that court. He was pretty good. I think Sarah has picked up a lot. She has the benefit of she's been studying her discovery for a long time. But what she hasn't been doing is watching court cases, I believe. And that's the court process of filing motions, the paperwork behind it, that's going to be probably a bit of a rough start for her. Teresa Super, thank you for gifting a membership. It's incredibly generous. That one went to Allie's Softball Life. Alley Cat, wait, there was a doc submitted by the judge that says this. Just joining, so sorry. Yes, the document right here. Let me scroll up to the top, Allie. The judge had a meeting today. This is the very bottom. It's a 16-page order, but the meeting was held because Patricia Cashman Esquire, her lawyer, filed a motion to withdraw in the last hearing, the same hearing that Sarah Boone handed the judge a 58-page handwritten letter. I think the lawyer moved to withdraw after that hearing, and it just now, they held the hearing for the motion to withdraw, but they didn't give anyone notice. So nobody knew this was coming up except for the participants. And the judge granted the motion, said, you're going to withdraw. Give all discovery to Sarah Boone, have it sent to her jailhouse. Jail's going to figure out how to give her discovery, and then you're free. And she's on her own. We're not going to give her any more court-appointed attorneys. She lost her representation, not intentionally. We're going to see this in the next letter, Anthony, and I would be surprised if it took more than a month for the letter to show up. But the next letter from Sarah Boone is going to be addressing this issue because she has to now, especially if she's against it. She has to do two things. She has to either tell the judge, this isn't fair, you didn't warn me, I didn't know, try to play that card, even though it's documented in all the docket. But she also, thinking ahead, she needs to look at this and say, I need to raise some money. And the best way to get a lot of people to hear about my case and possibly reach people who want to support me financially would be to write the judge a letter and then in that letter speak to those people. So I think we can expect to see something of that nature coming up very soon. Sarah Boone's like, Judge, why only 16 pages? Did you not have time to write the full letter? All documents for Sarah Boone and over 400 more cases are over on Discord. A big shout out to Discord, if I could. Our friends at Discord, this is not my Discord channel, but they are friends of the channel. They found me, or we found them very early on when I started live streaming. The Discord channel is As the Gavel Drops. They have done phenomenal work. If there is any court case happening in the United States that you are interested in, they probably already have a file on it. They've put together a calendar of the proceedings, what's happening. Any documents that have dropped, you can go over there. You can read the documents yourself without having to pay for them. They've done a lot of that work to put it together. If you go over there and do that and hang out there, it would be great if you're in the giving spirit to be able to boost their channel a little bit. They put so much work and effort into putting in all the documents. Giving them a little boost on there allows them to have more bandwidth, allows them to have a little bit more of the fun side of Discord as far as communicating with each other and chat groups and things like that. And that would be incredibly kind. But the link is there in chat right here. You can click on that link in the chat window and you can get over there to Discord. If you have any trouble there as well, they're super helpful in getting you started. Let's see. Somebody heard a buffer sound. I just need to see what it was. Lar H, so glad you found us. Yes, we're a Pickles, Not Politics channel where important topics like politics, religion, etc. should be had on a better platform than YouTube chat. Buffer, you forgot this part. There we go. Yeah, we do. I forgot this part about the channel. We have a little slogan, Pickles, Not Politics. I don't know why. I think I shared once that I was having pickles on my sandwich for lunch, and chat picked up on that, and it just became a thing. So I have pickle stuff, like yodeling pickles and everything else. I think there's the chat has given me. It's going to sing for a while. But we do say Pickles, Not Politics. And the reason I say that is not because politics are not important. I feel the other way. Politics are very important. They're too important to have the discussion on a platform like this. I think there are things that we should talk about with our neighbors, we talk about with our friends and our community, and I think you should be involved. But YouTube is probably the least effective platform, maybe second only to X, for effectiveness in political discussion. So we ask that it's Pickles, Not Politics here on the channel, and instead we try to talk about things that we're both interested in instead of trying to find our little differences where we might disagree. All right. I missed a couple things. What do you think Judge Wooten thinks about this? Judge Wooten was the previous judge before Judge Kranick. I think Judge Wooten is probably happy as well. Happy to be out of that picture. New subscribers don't even know about your soundbite commands yet. Yes, one thing about this channel, we like to have a little interactive fun with you guys as well. And so in times where we're not listening to heavy testimony in court or things like that, you might hear sounds in the background. I'll turn them up for a little bit because they'll just go nuts for just a minute. But they're commands that chat can play, like this one right there, that are little sound bites from courts that we've watched or trials we've watched or fun little moments that we've shared together. And it might be just
all that. Oh, that was terrible. I apologize.
Yeah, it might. It's a fun little time. Okay, that's a good example. Thank you. But it's a fun time to share.
Is that correct?
Somebody just sent me a video of roaches fighting. I don't know who won.
You might recognize some of them. You might recognize some of these voices, but anyway.
Tomorrow are we going to break for lunch, Judge?
Yeah. Anyway, some of the cases we covered, I'm going to turn it back down. That's what we do. We try to keep that limited to when we're not talking about court, when we're not listening, because really most of us want to hear court. We came to watch the trial. We came to hear the exchange and the testimony. So I tried to limit my discussion during trial to the minimum. And I also, using the gear that I have here, because I'm a bit of a nerd that way, I try to make the sound as best I can. So I have some, I would say more than the average equipment of being able to tweak the sounds, both crank the volume and remove noise, and make the listening experience as good as I would want it to be if I showed up to a channel that was showing court. So I pride myself on that, and if you have any problems that way, please let me know. We like to fix it. That seems like too much power for an audience. The audience is great. They really are. You guys. There have been many days where as soon as court starts, the commands just stop. And it's not that I turned the volume down. It's just they know that now's the time to listen, and they want to listen as well. So there are also a lot of secret commands that aren't listed. I have to put in the list that you just have to know about. But a lot of the comments you see on the screen like this are triggered by some of the commands are audio and some are a text response. But it is an amazing community. Honestly, I'm inviting you to come and join us and do it on the weekday. A lot of people watch this all day long or have it going in the background while they're at home, while they're at work. just as just a little something, a little filler sound to get them through the workday or the whatever's going on. So it's really good fun. As always, if you do lose your membership and you're not in a spot that you are financially, if it's just not the right time for you to join again, just make sure you have the gift setting turned on, because this community is absolutely amazing in gifting memberships. You'll see let's see if somebody can put there's the command. Thank you, Debbie. You go to this link, make sure the slider is turned on. The reason is YouTube doesn't want to gift you a membership to something that you don't want to be part of, right? So turn the slider on. All that does is just make it so that if a gift is given, YouTube knows that you're in the pool eligible to receive it. How they choose somebody, nobody knows, but they do try to. I think they pick people that interacted or some way indicated that they're interested in the community. So like there, Tisha S just gifted a membership by Kim R. Thank you, Kim. Kim, are you still our internet owner? Were you first in chat? I give away the internet first person in chat every day, but I think that was you. That was wonderful. Congratulations, Tisha S. That's great. Let's see. Mention Mrs. RA. My wife, Mrs. RA, has her own YouTube channel as well, but it focuses on homeschooling. We do homeschool our kids. We live in North Carolina, and we have 6 kids. Our oldest one is off at college right now and is about to get married in September. So we'll be driving across the country and attending that wedding. So I'll be doing work. We'll be live streaming from the road for about a month as we do that. During that month, I will be in Utah for the for the Corey Richens trial, which is the lady who's accused of killing her husband with a fentanyl overdose that she put in a Moscow Mule drink. And then she went out and wrote a book on grieving for her kids, and it was a national bestseller, and she did a whole book tour and everything. Well, now she's charged with his murder. Sort of puts a different twist on things. So we'll be out there physically for that court. I think we're going to see, Danny on Direct, that's her territory. She's going to be there. There might be a couple other people I'm going to be meeting up with out there during that trial. But we're on the pool. We're the media pool for that one as well. Let's see. Dodie, congratulations on 12 months plus. It's wonderful to have you here. Wouldn't be the same without you, for sure. Not going to mention your big deal. Okay, just because it's Friday, we'll do this just because it's Friday. We watched a court together. I regret this already, but it's too late.
People do not get to have it their way.
We watched a trial together with Judge McBurney, and it was a YSL trial. It's out of Georgia, I believe. And the trial had there had days where all we heard about was gangs, gang affiliation, gang signs, gang music, gang activity. And it was just nonstop. It was just gang education. And at the end of the day, we're like, the only thing left to do right now is to make our own rap song for the channel. And so I did, with a little bit of help. And let's see if I can find the right one here. Let's see. I don't want to play the wrong one. Nope, that's not it. Quit. We're going to try this one. Give me a thumbs up if you can hear this.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells, all rise and pay respect to the one and only go to true crime. Imitators, they try but they just can't achieve. And when they fail, they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe, because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal.
So that was the rap that we. I wrote the lyrics for that, and we put it to an AI to do the voice and the music. But it's good fun. We have fun like that. So it's Chat GPT for rap is basically what it was. My gang name was Big Dill, so I'm a big deal. Anyway, that was fun. Anyway, now you know all about the channel and probably a little more than you wanted to, but it was great fun. Anything else we need to cover? Just for those who came in late, Sarah Boone has lost her right to have counsel provided by the state. If she wants a lawyer now, she has to pay for it herself. Other than that, she is prosay. As of this moment, she is prosay, and we're excited because the biggest deal out of that, and she might get a lawyer, and I hope she does. I hope she gets a lawyer for her sake. But the big deal is that the firm information we've got is that the court date will not change. That this is going forward, and this fall we will see Sarah Boone in court, and there's going to be a reckoning. So, also the crowd draws thumbnails from time to time. Yes, there are many cases where we will show. Let's see if I can. Let me bring one up. There are many cases where we'll have a trial, and we'll do something like this, where we'll start documenting the events in the trial. This was the David Swift trial, but we have Chad Daybell's trial. We started documenting that one. We had the Trooper trial, and just anything that's brought up in court, whether it's evidence or something that's told from the stand or a little funny moment. This was the Arizona versus George v. Kelly with the Mexico border shooting, and we represent basically all the interesting bits in the court with the graphic on the screen, and this is all created by you, the viewers. So it gets a little bit wild. Here's my, I guess that's me. Oh, here's my gang sign. Yes, RA gang, I guess is what that one was.
Are we going to address subject matter jurisdiction?
Anyway, that's what we do. We have a lot of fun there. Let's see. Are you a poet? I've written some songs, like some real songs for guitar. I do play the guitar a little bit, but not very well. A J-Hatch interest is at Kaylee. Check this out. I happen to have a counter that's up to the second that is tracking. This is to the second how much interest has accrued in the J-Hatch case, the Mike Kowalski trial. Over 8 million in interest. That is just absolutely wild. But my son wrote that program that does that, so we track that. Mention your other channel too. The other channel is called Top Mark, all one word, Top Mark, like the very top mark, media. Top Mark Media, and that's where we. I don't speak on that channel generally. Usually we just provide a court feed from the court, and you can watch. And oftentimes we make that available for other YouTube creators to take that and restream and add commentary of their own if they'd like to, just because I think that everyone should be able to do that. There you go. Thank you, Amber, for the link that way. Appreciate that. Love the follow there. It means a ton to me. All right. I think... Is the cat still hanging around? Yes. Kiki, the cat, has adopted us, and it's still here. So I renovate bathrooms, too. We won't talk about that today, nor will we talk about my failed repairs of tractors, which I live streamed. I think that's all we're going to do today. It's Friday. I know you guys have plans for the weekend, and you deserve to have some down. Oops, that's the wrong one. That was Judge Manning. There we go. Hit the right button. Thank you, everybody, for coming out. I appreciate you guys. The support you give this channel is amazing. It's what makes it possible, what makes it be able to do what we do. From me, from my wife, from my kids, thank you for your support. It means the world to me. For all those who are at work or somewhere else fun, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow. Nope, let's say Monday morning at 8:45 in the morning. We have Verdict Watch again on Monday. Let me just check the calendar to see what else is coming up. Probably should have done that a little sooner. Laura K, congratulations, 13 months. Let's see. Kim R gifted a membership. Artie Bay, what an absolute crazy day. Who would have ever thought that Sarah Boone could be a palate cleanser? Selena K gifted a membership. Thank you, Selena. Jen Javier, love this channel, the community you've created for SRA. Thank you for keeping us informed and entertained. And then, yes, Alley Cat, we got the doc there. If you want a copy of the doc, go over to the Discord channel. It's over there. You can get a copy of that yourself. Teresa Super gifted a membership. Courtney Arleo. Courtney, you're going to have to change your name because I just want to call you Courtney I give up. I really do. Fun and Funky, thank you very much. Jane, appreciate that. To everyone who gifted memberships, to all the mods, thank you. We're going to take the rest of the weekend off unless something crazy happens, and then, of course, we'll be back like we always are. So, coming up next week, let me see. We've got Ashley Benefield coming up next week, I think. The Black Swan trial. Ooh, sounds good. Maybe Microsoft as well. Be good to each other, you guys. We'll see you. Have a great weekend. Bye-bye.